For many of us, a home is a rented house or apartment. And if you are a tenant, knowing your legal rights is essential. I'm Professor Rick McElvaney at the University of Houston Law Center. If you're a tenant, you should understand how Texas law affects your relationship with your landlord. Knowing the law will prevent problems and help you settle disputes. The legal relationship between a landlord and a tenant is primarily determined by the lease. A lease means any written or oral agreement between a landlord and a tenant that establishes or modifies the terms, conditions, rules, or other provisions regarding the use and occupancy of a dwelling. If a lease is for a term of 1 year or less, there's no requirement for it to be in writing. Leases for more than 1 year, however, must be in writing. If you have a verbal lease without a set period of time, Texas law requires at least one rent-paying period's notice for you to terminate or any changes in the rental agreement. For example, if you are a month-to-month tenant paying rent once a month, you need to have one rent-paying period's notice for any change or termination of your lease. Most landlords and tenants, however, have formal written leases and have a rental application process involving an application fee, application deposit, and tenant selection criteria. Before signing your lease, you should do your due diligence. Inspect the area where the apartment is located. Does the area flood in heavy rains? Is it a high crime area? Inspect the apartment you are going to rent, not just the model unit or a different apartment, to ensure it is a place you want to live. Once you sign a lease, you'll be bound by its terms. There are very limited reasons to terminate a lease early, such as military transfers. So make sure you want to live in the place and can afford it. Changing jobs, getting married, or moving to a new city are not valid reasons to terminate a lease. In addition to your first rent payment, your landlord will require a security deposit to protect against damage to the apartment. It is important to remember, normal wear and tear is not considered damage. Many people believe that getting your security deposit back can be difficult, and many landlords retain security deposits as a matter of course. However, landlords who do so at their own risk. Under the law, a landlord is required to refund the security deposit or provide an itemized list of deductions within 30 days after a tenant moves out at the end of the lease and provides a forwarding address. A landlord who does not comply with these requirements is presumed to be in bad faith. If a landlord is found to have withheld a security deposit in bad faith, a tenant may recover a $100 statutory penalty, 3 times the amount of deposit wrongfully withheld, court costs, and attorney's fees. If a landlord fails to give an itemization and cannot overcome the bad faith presumption, he cannot claim any damages to the apartment or retain any of the security deposit. Texas law protects tenants from landlords who try to take advantage of them. Knowing the law will ensure that this doesn't happen to you.